Good morning, everyone, and welcome to ILM University. It is my pleasure to welcome Dr. S.Y. Qureshi, former Election Commissioner of India and Chancellor of ILM University, Honorable Justice Madan B. Lokur, Chairman, Governing Body, ILM Law School. Also welcome Professor Ranveer Singh, Founder Vice Chancellor of National Law University, Delhi, and presently member of Board of Management, International Associations of Universities, Paris. Also welcome Mr. Jyoti Sagar, a member of our Board of Governors, founder of J. Sagar Associates, KNS Partners, India's leading law firm, faculty members, colleagues, and students. I'm grateful to all our speakers who have taken out time from their busy schedule to join us on this faculty development program. You know, communicating effectively is very important in anyone's profession. When we talk of a lawyer's work, legal writing is the most important thing. Today, the topic of this faculty development program is the art of legal writing, which is the central medium with which a lawyer communicates his or her work. Legal writing teaches students how to use knowledge in practice. So without taking much of your time, I would like to introduce our eminent speakers of this panel. Although I don't think our eminent speakers need any introduction as they are the legend in their respective fields, but I would like to share some of the achievements of our speakers. Dr. Qureshi, born in pre-independence era, June 11th, 1947, Dr. Qureshi is globally well known as a development thinker. He completed his master's degree from St. Stephen's College, Delhi. He joined the Indian Administrative Services in the year 1971, where he served for more than 35 years. He is a renowned scholar of several languages and was awarded with PhD for his thesis on role of communication and social marketing in development of women and children. In the year 2010, Dr. Qureshi became the 17th Chief Election Commissioner of India. Prior to this, he has held the offices of Special Secretary Health, Director General of National AIDS Control Organization, Secretary Ministry of Youth Affairs and Sports, and Director General Doordarshan. As an educationist, Dr. Qureshi has a number of books, articles, talks to his credit. His book, Social Marketing for Social Change, has broken new grounds in the field of development communication. He is also the author of An Undocumented Wonder, The Making of the Great Indian Election and the Population Myth. We at ILM are so thankful to have you with us, Qureshi sir. Now I request Dr. Qureshi to share his views on the topic, the art of legal writing. Sir.
Yes. Yeah, thank you very much, Sujata ji, and this is Lokur, Professor Ranveer Singh, and
yes,
and my friend Jyoti Sagar, who will join in a while. And ladies and gentlemen, you might be wondering, what am I doing here in the webinar on the art of legal writing? I do have some credentials which I'll share with you, and if Justice Lokur admits them and accepts me as a person who can speak on the subject, I'll be honored. First of all, a very irrefutable thing which even Justice Lokur has no discretion on, I'm the host, therefore I can speak. So now, you know, although I don't have a law degree, but the way we are taught law in the National Academy of Administration for 2 years, CRPC, IPC, the most boring CPC, Evidence Act, every virtue possible law which we have to deal with, we are taught in what is called a professional course, which is considered of a MA level. So unfortunately, they don't give a degree, although it will be a good idea if they start giving a degree. Then when we go to the states, in our revenue training school, we learn all the revenue laws, the Village Common Land Act, Land Acquisition Act, all the acts which we need in our tenure, in our career in the state. Now, also have sat on the bench for as long as 16 years, which is more than half of the whole tenure of half the lawyers of the country. As first as assistant collector, then as collector, then as divisional commissioner, then as financial commissioner, and finally as chief election commissioner and chief election commissioner. And the last one particularly, I'm very proud to say that not a single top lawyer of the country, there is not one who has not appeared before us in the election commission. You name any and sure they have appeared, many of them, several times. And so therefore, I do have some exposure and some experience of law. Now, one lesson which I have learned, and in fact, I remember reading about it. I can't remember who said it, but he said that the judges, even if they do not, they are not experts of all the laws, they don't have to be, because it is the lawyers who teach them the law. Both the side, they present the law, and on which basis you exercise your judgment who is saying the right thing. And finally, I have only one lesson, which I have learned from my own experience in life. It says a 3-word advice about legal. Now, for legal writing can be of various kind. Right, the lawyers writing their petition is also legal writing. Judges writing their judgment is also legal writing. The media people are commenting on writing on the judgments or legal issues. So that is also legal writing. But here I'm only focused on the writing as a judge. Now, there are 3 keywords, and they, to me, they are the ultimate wisdom. Write a speaking order. And it has to be so good that the appellate court has no possibility of overruling it. Or if they want to overrule it for any reason, they will have to, you will give them a tough time, because they will have to refute all the argument. Why you came to such a judgment has to be explained in a speaking order. That is, according to me, the key word. Now, I therefore, and this was something which was taught to me in the academy, for which I got no degree, by the way. But they say that if you write a speaking order, chances are that your judgments will be upheld. I do not remember in my 16 years any of my judgments getting overruled, although some of them went up to the Supreme Court. Never was it overruled. But number one, it was fair and honest. And secondly, it was a speaking order, and which is why the courts found it sustainable, and they always upheld it. Now, with these words, I'm very happy to welcome 3 luminaries to give the wisdom of their experience to all of us, and I thank them profusely for agreeing to participate in this. This is our inaugural webinar, and in any case, Justice Lokur is our chairman of the governing body of law school, and Mr. Jyoti Sagar is a member of the board. So with them there, we expect some very seminal workshops and seminars to follow. Thank you very much.
Thank you, sir, for your insights about 3 keywords and guidance on the important aspect of legal education. Now, Honorable Justice Madan B. Lokur, it is indeed a matter of honor and pride to introduce our chairman and board of governors at ILM Law School, Honorable Justice Madan B. Lokur. Justice Madan B. Lokur is a judge extraordinary, a man with a blend of goodness and greatness. He is known for his simplicity, sincerity, intellect, and for graciousness. His judgments are worth to be quoted for legal actions. He possesses a vast experience in civil, criminal, constitutional, revenue, and service laws. Justice Lokur, born on December 31st, 1953, he graduated with history honors from Stephens College, Delhi, and obtained a law LLB degree from Faculty of Law, Delhi University. In 1977, Justice Lokur was designated as senior advocate. Since then, he has never looked back. In his 41 years of legal profession, he has contributed rigorously and with full sincerity either as an additional Solicitor General of India, additional judge of Delhi High Court, Chief Justice of Guwahati High Court, Chief Justice of Andhra Pradesh High Court, and as Judge of Supreme Court of India. While all of these came from his work on the judicial side of court, he also set up the National Judicial Data Grid to provide an all India case management system with the use of latest technology. People admire Justice Lokur for protecting Aravalis and for protecting the Taj Mahal from the industrial pollution. Justice Lokur has shaped the human rights jurisprudence with compassion and humanism. We at ILM are proud to have Honorable Justice Madan B. Lokur as Chairman, Board of Governors, ILM Law School. Sir, I would like to invite you to share your thoughts.
Yeah, thank you, Professor Shahi. Dr. Qureshi, Professor Ranbir Singh, and Mr. Jyoti Sagar, and all the participants today. The topic of legal writing is, quite interesting. One of the reasons why I think it is interesting is that no one has paid attention to it. Although we are dealing with legal issues on a day-to-day basis, but how do you present those legal issues when you write about them is something that we have not paid attention to. So I'm very glad that this topic of legal writing has been taken up for discussion today. I hope there will be many more of such discussions so that we can bring some sense into issues of legal writing, some of which I will highlight during my presentation. Now, I have classified legal writing into 5 different categories. The first is legislative writing. How do you draft laws? That is legislative aspect of legal writing. The second is judgments. How to write judgments? What are the requirements of judgment writing and so on. The third is professional legal writing. Drafting of contracts, drafting of complex documents. Mr. Jyoti Sagar will be addressing you on this issue also. The fourth is academic writing. That is commentaries, research papers, and so on. This is also extremely important, and I'm very glad to say that there is a lot of academic writing, academic legal writing that is coming out in the country today. And there are many, many young lawyers, including law students, who are doing a lot of academic legal writing. But Professor Ranbir Singh will, I'm sure, deal with this topic in much greater length. And the fifth and final category that I have, I would call it miscellaneous legal writing or other legal writing. So you will have articles, which are written in the newspaper, for example, on some issue, or you have some journalist expressing a point of view. You could have something very important like a will, which is written by a person. It can be written by a person, and it is valid as long as it is, witnessed by 2 adult persons. So really, it's not such a complex subject, but I think we in the legal profession have made it complex and given the word legalese to the dictionary, something which only lawyers can understand, other laypersons cannot understand. So I will come to the first category, that is legislation. Now, legislation is of different kinds, in the sense that you have primary legislation, that is laws made by Parliament. Then you have subordinate legislation, that is rules which are made under the law. So the law gives power to make rules. And you have regulations which deal with actually procedure and how much of fee has to be paid for a license, things like that. But all these are would fall in the category of legislative writing. Now, this is very important because there are two or three things that we must understand. One is that the legislation has to be simple. It is something that you and I and anybody else on the street can understand. If the law is complex, then it's impossible to follow it. I will not be able to understand what the law is, and therefore, I might fall foul of the law, and in that event, I will get some punishment. So the law has to be very clear, and the intention of the legislature must be made very clear in the law itself. As judges, as lawyers, we try to find out what is the intention of the legislature. Why has the legislature enacted a particular law? Now, it's very difficult to find out because if in a parliament, for example, where you have so many members, you will get so many different viewpoints on a particular law or on a particular section of that law. So how do you find out what is it that Parliament intended? One way of finding out is to look at the statement of objects and reasons, which is given when a law is placed before Parliament. But that by itself will give you a broad idea of this is what the legislation intends to do. But what does a particular section intend to do? Why is that section there? Why are those words over there? So this is, something which is very difficult, and a lot of time is actually spent on lawyers arguing what is the intention of the legislature, and of judges trying to find out what is the intention of the legislature and then putting it down in a judgment. So really, judges and lawyers are guessing the mind of the legislature, which is something very, very difficult. So that's why there has to be a need for a detailed discussion on what the law is, what is it that the legislature intended, whether it's Parliament or whether it's the state legislature. There has to be a greater discussion in the law. One of the ways of understanding the law, it was laid down as a rule many, many years ago, a couple of 100 years ago, something called Hayden's rule or the mischief rule. Now, it came out of a judgment. What that lays down is what was the law earlier, right? So if there was no law, what is the common law that was in existence earlier? What is the mischief that is sought to be controlled or that is sought to be resolved? What is it that has happened that has made you to legislate? Third, what is the remedy that is being provided by the law? Is there some administrative remedy or is it some judicial remedy? Is there an appeal and so on? And fourth, what are the true reasons for this remedy? So if you had a law earlier, why are you enacting a fresh law? Is there something that has gone wrong with that law? What is the mischief that you're trying to cure? What is the remedy that is available? What is wrong with that remedy? Why are you bringing in a new remedy or a modified remedy? These are all questions that arise during legislation. I would like to give you two examples about simplicity and the choice of words. The laws that are enacted in India follow a particular pattern. There was one departure, and that departure was when the Arbitration and Conciliation Act was enacted in 1996. The idea was, let's make it simple. After all, who are the persons who are going to go in for arbitration? It's only ordinary people, small corporations, maybe big corporations. So let's make the language simple. But in that simplicity, it has caused such a huge amount of complication that the Supreme Court had to sit in a bench of 3 judges, then they had to sit in a bench of 5 judges, then they had to sit in a bench of 7 judges to try to understand what is the law. So really, in the process of making the law simple, the Arbitration and Conciliation Act has complicated the entire thing, and it has led to so many amendments and so many judgments, so many interpretations. So one has to be very careful in the choice of words. So while simplicity is a good goal to achieve, the choice of words is important. In this regard, I would like to mention about a law which said that vehicles are not allowed inside a park. Now, what is the definition of vehicle? That was not given in the law. So if somebody takes a pram with a baby or an infant, it's a vehicle as far as the infant is concerned. So that does it mean that you can't take a pram inside the park? Today you have kids on skateboards. They travel from one place to another if the road is smooth enough. And if they take a skateboard in the park, is that prohibited? It's a vehicle of movement. So the choice of words becomes important. Simplicity and the choice of words, these are very key issues that arise when you're drafting legislation, apart from the hidden rule or the mischief rule that I have adverted to. Second is about judgments. That is the second category. For whom are you writing judgments? If you ask a judge, are you writing a judgment for the lawyers? Are you writing a judgment for the litigants? Are you writing a judgment for the parliamentarians who have made the law? For whom are you writing the judgment? I think that the judgment must be written for the common person, so that everybody knows what is the law. So the judgment also has to be simple. It has to be in easy language, which you and I can understand. And that is one of the reasons why the Supreme Court is now insisting that judgments of the Supreme Court should be translated in different languages. Why? Because it is written for the people. And the people should be able to understand the judgment. If it is written in English, it should be simple English. It can be something which it should be translatable into regional languages, which is what is happening, so that persons who do not know English can understand the judgment. Now, we've had strange instances of judgments being delivered. There is an article which I would request all of you to read. It's called Judgment by Thesaurus. Now, a judge of the Supreme Court wrote this judgment which nobody could understand. The first sentence in that judgment was about 170 words, right? No full stop except after 170 words. The second sentence was equally long. Now, how do you understand a judgment like that? I mean, I think even judges cannot, sometimes understand those kind of judgments. I remember being in court one day when a bench was being presided over by Justice H.R. Khanna. Justice Krishna Iyer was a great judge. I mean, there's no doubt about it. I don't think anybody has any doubt about it. But the language that he used was somewhat complicated. But he wrote very well. So even if the language was very complicated, you could somehow or the other make sense of it. Somebody cited a judgment before that bench. And the presiding judge asked, who has written this judgment? So the lawyer said, this has been written by Justice Krishna Iyer. So the judge remarked, in that case, whatever you say, I will accept it. I don't have to read the judgment because I will not be able to understand. Right? So the language has to be simple. Now, you can use big words, but why? Benjamin Franklin says, if you can use a small word instead of a big word, please use a small word, so that people can understand it. But at the same time, it should not be so simple that it becomes, a bit of a joke.
Meaning is lost.
I will give you two examples. One is somebody who was asked to pay a tax. He came to court and he told the judge, he said, As God is my judge, I do not owe this tax. So the judge passed a judgment in which he said, he is not, I am, you do. So, I mean, the judge conveyed whatever he wanted to, but it becomes a bit of a joke in this manner. There's another one where a lawyer wanted to distinguish the facts of one case from the one that he was arguing. And after having argued, the judge wrote, he didn't, we couldn't, judgment affirmed. So he didn't distinguish the facts, we couldn't distinguish it, so judgment affirmed. 5 or 6 words. That's not, how judgments should be written. I mean, these are, extreme examples, but they're there. We've had to deal with judgments which are absolutely unclear. I've had to deal with one of those in the Supreme Court. I was reading it in late evening. I couldn't understand it. So I thought, let me read it the next morning when I'm fresh. I read it the next morning. I still couldn't understand it. When I went to the court, I asked my brother judge, I said, have you understood what is written in the judgment? He said, I have not. We asked the lawyers, what is the judge trying to say? And they very frankly said, we've not understood it. One of the lawyers actually said that I contacted a friend of mine who's a professor in English, and even that professor in English couldn't understand it. Now, what is the use of a judgment like that? We had to set it aside on the ground that it is incomprehensible.
Yeah.
Unfortunately, that judge has not realized that he should write comprehensible judgments. Recently, about a month or 2 months ago, he wrote another judgment, which the Supreme Court could not understand. So, just because you have this learning, big words, doesn't mean you have to put them into your judgment, which nobody can understand. There has been an instance in the Supreme Court. Justice S.B. Sinha has, in fact, begun his judgment by saying that a particular judgment is so unclear that a bench of 5 judges has been constituted to interpret that judgment. He said it's the first time it has happened in the history of the Supreme Court. So, judgment writing is an art. It is for the benefit of everybody so that people can understand it. If judges of the Supreme Court are unable to understand judgments, what is the use of that judgment? Okay, so simplicity is important, but not the extreme kind of simplicity, the 2 examples that I gave you about. The other problem with judgments is the use of Latin phrases.
Yeah.
Judges use Latin phrases left, right, and center. Latin is a foreign language to us. English is a foreign language in a sense, but Latin definitely is a foreign language for us. Even for the British judges, it's a foreign language. So you have, all kinds of maxims, as they say, in Latin, which are, peppered into judgments. Res ipsa loquitur. It means the thing speaks for itself. Now, what thing speaks for itself and what does it speak? We don't know. But it's nice phrase, res ipsa loquitur, so we use it. So you have all these Latinisms. Now try to imagine, a converse situation. If you are writing something in Hindi and you start, using Sanskrit words, Sanskrit is a language that is ours. It's not a foreign language for us. If you start using Sanskrit while writing, a judgment in Hindi, district courts write judgments in Hindi, who will understand it? I mean, none of us are literate in Sanskrit, very few. There are people who are literate in Sanskrit, but hardly anybody is literate in Latin. So why should we use these Latin phrases? I think we have to get rid of them. So again, simplicity, short judgments. You don't have to write judgments which are 200 pages, 300 pages. Avoid Latin phrases and use simple English. The third category, in my view, is that of professional legal writing. Like I said, Mr. Jyoti Sagar will speak about that. But just a few words on this. You have contracts and other documents, legal documents, which are drafted day in and day out by professional legal lawyers. Again, clarity is required.
Highly confused.
I've had to deal with complex commercial contracts as an arbitrator. Now, one of the essentials of the contract is that both the parties should be on the same page. They know what they are signing, they understand what they are signing. But most of the disputes that I've had occasion to deal with as a judge and now as an arbitrator is on the interpretation of a particular clause in a contract. So one party says, this is how I interpret it. The other party says, no, this is how I interpret it. Now, where is the meeting of minds? If two parties say completely different things about the interpretation of an article in a contract, there is no meeting of minds. Now, if there is no meeting of minds, you could very well argue there is no contract. So this, is something which has to be clear, because of the language that is used in some of these contracts is so complex that it becomes very difficult to understand what are the parties trying to say. One extreme example that I will give you, which is quoted, quite frequently on topics of legal writing, how a lawyer would write a sentence: I give you this orange. That's 5 words. I give you this orange. If you ask a lawyer to write it in that legalese, that lawyer will write, I will just read a part of it because it's very long. Know all men by these presents that I hereby give, grant, bargain, sell, release, so on and so forth, my right, title, and interest in this chattel, otherwise known as an orange, together with skin, pulp, pip, rind, seeds, and juice. That's how a lawyer will say, I give you an orange.
Orange.
Now, if somebody comes to you with a sentence like this, what sense can you make out of it? I've given an example of an orange, but then it could be anything, some machine, maybe a book, with words printed in it in black ink and this, that, and the other. Instead of saying, I'm giving you a book, you write a big, long thing, paragraph. So these are, issues of simple English and English that you and I can understand. Lawyers tend to use what are called lawyerisms. I think we should avoid those. Things like hereinbefore, hereinafter, aforementioned. Do we need these kind of words? Said. The said street, the said man went on the said street to the said house. I mean, I'm sure it can be made much simpler than just using the word said so many times in one paragraph. So these, again, I'm sure Mr. Sagar will expound on this. But again, the point is of clarity, of being understood clearly by everybody to whom it is being addressed. The fourth category is that of academic writing, which, like I mentioned earlier, commentaries, research papers, thesis, case studies. Professor Ranveer Singh will, I'm sure, speak on this. But the audience in this category is different. You're writing a thesis for a particular purpose, academic purpose. So only academics are going to read that. It's not the person on the street who's going to read it. So really, some of the, of course, simplicity must be there. And some of the, a little bit of play in the joints, so to speak, must be given to these academics when they're writing these kind of thesis and research papers and all that, because like I said, the audience is different. So maybe a little bit of leeway can be given, but clarity must be there. It should not be so obtuse that even an academic doesn't understand.
Yeah.
So if judges write judgments which judges cannot understand, there is no reason why academics should write thesis which academics themselves don't understand. It has to be clear what is the point you're trying to make, what is the central point of your thesis, and how are you expressing it. This is very, very important. Then the fifth category is that of other legal writing, which is articles. Journalists and reporters, they write day to day on legal issues, that this is what happened in this case, these are the broad facts. You have persons who are filing PILs, public interest litigation, in person. They must also be clear about why are they filing this public interest litigation. It must be clear so that the judges can understand. Now, if that person writes something in a language which nobody can understand, judges cannot understand, the purpose of the public interest litigation goes away. And this is one of the reasons why the Supreme Court has said we will entertain letter petitions. So you don't even have to write these, big petitions which run into 40, 50, 60, sometimes 100 pages. Lawyers tend to do that, huge, petitions with the evidence in it and all kinds of things in it other than the facts. You have a will, which anybody can write. You don't have to go to a lawyer to write a will. Anybody can write a will. Now, if that will is written in some complicated language, how is it going to be executed? Who are the beneficiaries? You have to be clear about that. You can't write a will and say that, after my death, let people try and understand what I've written in my will. So if these kind of documents, a will is a very, very important document which survives a person. If an important document like this can be written by a lay person, by the man on the street, and which can be understood by everybody else, why is it that most of the other kind of legal writing, judgments, legislation, so on and so forth, cannot be written in that simple language? So I'll just wind up by, just summarizing a few broad rules. One is that the audience that is being addressed is important. So you have the audience of the laypersons, the man on the street, the woman on the street. You have academics, two broad categories. Simple English runs through the thread, all five categories of legal writing. Avoid big words, avoid Latin, avoid, long sentences, long judgments, long articles. There has to be clarity. The definitions have to be clear so that people understand what you are talking about. Then examples should be given. Very easy, very good. The IPC, if you go through the IPC, they have illustrations. Why? So that the section can be understood. Evidence Act, they have illustrations. Contract Act, illustrations in that also. Why? So that it can be understood. So there is absolutely no harm. In fact, I would say that it should be encouraged that in legal writing, examples should be given. It could be through a footnote, it could be through an annotation, it could be through an explanation, it could be through a comment. But this will be extremely helpful to understand what the author is trying to say. Finally, 2 points. When you're doing legal writing, your first draft is not always the best. There is a professor of English called Professor Raymond. He says that great authors, renowned authors, they write their book maybe twice, maybe 3 times until they are sure about what they want to convey. He says he has come across an author who has written the same book 8 times, draft, and the 8th one he has approved. So you have, these people who first draft, they don't accept. That's what makes a good author also. The second example I would like to give is that of one judge called Justice Holmes. of the United States Supreme Court. He wrote very short judgments, very clear, very short. Somebody asked him that, how do you manage to write such clear judgments and such short judgments in such few words? You write so beautifully. He said, I'm an old man, so I stand up and I write by hand. So either my legs get tired or my hand gets tired. So I have to be brief.
Brief.
And that's how his judgments are very well received by everybody. So these are some issues that I just wanted to place before you for legal writing. Thank you very much for your patience. Thank you.
Thank you, sir, for your guidance on importance and fundamentals of legal writing, and especially the classification of legal writing. I think this will help our students, faculty to learn more about all these 5 classifications. So once again, thank you, sir, for being here. Now I would like to invite Professor Sanjay and Professor Rahul to take forward the next session.
After hearing Justice Lokur, one conclusion is very clear, and Mr. Jyoti Sagar and Justice Lokur will agree that I thank God that Shashi Tharoor is not a judge, because there is no second Shashi Tharoor to understand his writings.
Good morning, everyone. It is my privilege to introduce an esteemed member of our Board of Governors, Mr. Jyoti Sagar, who has been in the legal industry for over 4 decades. He founded J. Sagar Associates in New Delhi in 1991 as a solo practitioner, a firm that was the torchbearer of meritocracy and democracy, and has since consistently ranked amongst the top law firms in the country. In 1994, he founded K&S Partners, an intellectual property boutique firm, which has an equally well-established presence in annals of the Indian legal practice. He has experienced and also extensively researched the gaps between the academic learning and professional practice in law, and thus strongly professes the role of each of the components of strong communication skills for a law graduate. Mr. Jyoti Sagar is recognized as Associate President, Society of Indian Law Firms, as well as past President of Asian Patent Attorneys Association, and currently serves as one of its international vice presidents. Mr. Sagar's outstanding contribution towards society is evident in his various roles as trustee Genesis Foundation, which had its origins from a belief that every child has the right to live a healthy life, hence providing critical medical assistance to underprivileged children suffering from a congenital heart defect. He is also the chairman, Society for Urban Regeneration of Gurgaon, focusing on long-term sustainable development issues of Gurgaon. He also supports Dipalaya, which engages in the education of slum children. Once again, it's an honor to welcome Mr. Jyoti Sagar in recognition of his work that puts a spotlight on legal writing, and I look forward to sharing in everyone's enthusiasm his work and experiences in this field. Sir, may I now request you to share your views. Thank you.
Thank you. Thank you, Sanjay, for that very generous introduction. So friends, I'm delighted to be here today with all of you. And it was indeed very nice and wonderful to hear Justice Lokur just before me. And he's covered quite a vast canvas, so to say, and areas which are of extremely important. Now, I personally have been kind of engaged in a little bit of research and study on the issue of language of the law for the last, I would say, 20 years, but more seriously, the last 5 to 7 years. And what led me to it actually was an interesting story of an old lady who walked in to see me once, and she walks in and she sort of says that, I really don't understand how you lawyers write. So who's this party of the first part and who's party of the second part? And and all those words of whereof, thereof, and hereof, and so on and so forth. And why can't you just simply write, I have to read it. You must keep your reader in mind. And it just struck me as a bolt of lightning. And I sort of, realized, as Justice Lokur rightly said, that you have to look at your audience. Now, starting from that point, I kind of tried to figure out that why is it that language of the law, and I'm talking now of obviously language of English language of the law, is what it is? What makes it what it is? And why is it that we haven't changed, that this is kind of thing which continues and has continued for a long time, and it led to really, for the first time, even for myself, after having been in the profession for well over 35 years at that time, to start looking at some of these things. So today, in a way, I was asked to speak on specific contracts like mergers and acquisitions and sale contracts and so on and so forth. But I just taken the complete liberty of completely turning that, or rather putting that subject aside altogether, but continuing in a way, more focused way on some of the issues that Justice Lokur has raised. And why I think that's important? Because I think what's important is not how to learn to write a particular clause, but it's important how to write at all. It is important that the way we write, the language we use, and the way, because language is just merely a tool. It's merely obviously it's the most important means of communication, so to say. And for us lawyers, we have to simply unlearn a lot that we were told and we picked up. And I'm very happy that the audience today is obviously of many young people who are aspiring to be lawyers. And I'm really delighted that I have an opportunity of trying to tell them a few things before their brains and their minds start getting polluted with legalese and with legal language. So what I do have, so I changed this whole thing around to say, I'm going to talk about the history of the language of the law, because it explains why it is what it is and what are the problems with it and how you can avoid those problems, and then go into the sort of the latter part of my presentation is on plain English. So in other words, by the end of it, I hope that I would have planted a seed which can grow of curiosity, of learning more about the language, of avoiding the pitfalls, and how you can really write for your audience. So with that, with that context, I will now share my presentation. I do have a presentation that I made. So let me go straight to that. So let's see now if I can share my screen and see. This is the one, and here it is. So can you see it? Can you see the screen now, please?
Yes, yes.
Okay, so let me now have a go at it. So as the title is, hereof, thereof, and whereof, what's wrong with the language of the law, and a brief introduction to plain English. All right, so let's just simply talk about language for a minute. As I had earlier mentioned, and as Justice Lokur mentioned as well, language, the purpose of language is communication. How to communicate. And what is the purpose of communication itself? Understanding, readability, comprehension. And when you look at something that you read or something that you come across, as Justice Lokur was describing the Himachal High Court judgment, I have something to say about that. Actually, I do have the wording of that, and I have Justice Lokur's comments, which got published in the newspaper, which I'll share with you later in this presentation. I also have with me the famous first paragraph of a judgment which had much comment on its language, and that also was just referred to by Justice Lokur. I will talk about that as well. So when you read something and you look at something, these are the kinds of words, as single words, that may come to your mind. Now, the purpose, as I said, is to communicate. So just let's look at it now to say how language is the critical component of law. So what, as Justice Lokur explained, law is a law of words, whether it's regulations, opinions, contracts, private documents. And words are also our most essential tool. We are wordsmiths. That's what we do. And these days, certainly these days, it may not have been the case in the past as it was, and I will talk about that as part of history of the language of the law. Now law impacts everyone. It impacts everyone, the proverbial common person on the street. Now, as I was telling you the story of that old lady who came to see me about a lease that she wanted to sign. Now, we all know that how legal English, how different it is dramatically from our common day, everyday speech, to the extent that it's incomprehensible to non-lawyers. So why is that? And how is that? So let's just look at it from the beginning. I say that there were two most significant exports from England ever. One was the common law, and the other is the English language. And literally, in a way, legal English is an amalgam of those two things. And former colonies of the British Empire, so we inherited English, but we also inherited common law, and it's, as I call it, its inseparable twin, which is legal English. So what is legal English? There's distinct phrases, words, and expressions. And the second part of it, so first part of it is the vocabulary. And the second part of it is the manner of composition, or how we construct this, how we actually write the language actually. So what we have in the language of the law actually is, and I'll describe that as we go along, is accumulated baggage, I call it, of centuries. And I'm talking centuries means 1500 years. And during that time as well, in parallel, English as a language started evolving, and that's more after the Norman conquest in about 1100 AD. But post that period, it's almost as if the language of the law and common speech just have diverged. They've actually followed literally two separate lives or histories. So let's look at that. And the problem with the language of the law is not now. One of the first, so to say, in literature that I found, believe it or not, is Gulliver's Travels, Jonathan Swift, 1667, 1745. And this was, what I'm going to give you here, was 300 years ago. So he wrote of a society of lawyers who spoke in peculiar cant and jargon of their own that no other mortal can understand. Now we move 200 years. And I take you to Will Rogers, who was one of the very interesting characters. He was an actor and columnist in the 1920s and 1930s. And the American Bar Association, to its horror later on, realizing, they invited him to be a keynote keynote speaker at their Los Angeles meeting in 1935. And this is what Will Rogers said in that speech. The minute you read something and you can't understand it, you can almost be sure that it was drawn up by a lawyer. Then if you give it to another lawyer to read and he don't know just what it means, when, why, then you can be sure it was drawn up by a lawyer. If it is in a few words and is plain and understandable only one way, it was written by a non-lawyer. Every time a lawyer writes something, he's not writing for posterity. He's writing so that endless others of his craft can make a living out of trying to figure out what he said. 3 months after this speech, Will Rogers died in a mysterious plane crash in Alaska, but no lawyer claimed any responsibility. Here is another one of my favorites. Prima facie, I concur that I shall indeed accept between 2 and 3 portions of the proffered crystalline substance in full and final settlement. Oh, that'll be 2 sugars then. It is the example of the orange that Justice Loker just gave to us. This is what happened to that old lady who came to see me. Party of the first part and party of the second part. Okay, people are confused with it. So let's just go a little bit deeper. So 2 parts to it. Words. So there are words with uncommon meanings. I'll share it with you. Antique, fancy words, Latin and French words, jargon, too many words and big words. And on the construction side, we have long sentences, passive voice, nominalization. I'll talk about that a little bit, prepositional phrases, and compound constructs. So I'm going to just give you a flavor of each one of these. So let me, okay. So we actually in law use many words, which are common words, but they carry a very different meaning for lawyers. And that's very confusing for non-lawyers. So let's see this here. Word, action. So we talk of it as a lawsuit or other legal proceedings. In common speech, it's just an act, a thing done. Process of doing something is an action. Demise. So we do transfer of property by lease. For everyone else, it's a person's death. Executed. We say signed a document. For everyone else, it's a sentence of death. Motion, an application to a court. For others, it's process of moving. Presents. For us, this document in these presents, as we write, nobody understands what it means. For everyone else, it's gives or introduces. Save. For us, it's accept. It's an exception. For others, it is keep safe or rescue or store for the future. Let's look at words of antiquity. You had a flavor of that from Justice Lokur. So I'm going to talk about these 3 phases of history of the English language. So the Old English is 500 to about 1100 AD, which is the Norman conquest when the French came and conquered England. Middle English is from 1100 to about 1500. And then modern English is onwards. But obviously, there's an origin, so it has much of Old English and Middle English. However, many words of OE and ME are not in common speech English today. But we have retained those words. And now the words that are going to come here, believe it or not, are over 1,000 years old. Aforesaid, henceforth, forthwith, thenceforth, therein, herein, thereabout, whereby, thereby, thereon, all the heres and their words are all more than 1,000 years old. They are not really used in common speech English, except they're used by lawyers as if it was absolute the normal thing to do. So we also have what I call fancy and pompous words. We pretend to be more important than we are. And we pretend to say things so that it gives weight to those things, whether it is in judgments or whether it is in our writing. So lawyers always advise. They don't inform and they don't tell anyone. They advise. We always append a document, never attach it. We ascertain facts. We don't find out facts. Consequently, and thus, we always endeavor, but we never try. And envisage, and we don't foresee. Now, the rest of the world doesn't really run into these words all the time. They run into these words all the time. Okay? Latin and French words. Now, this is a very interesting part of the history of the language of the law. English is, as languages go, comparatively a young language. It has been borrower of language words from many, many languages as it evolved. And in law, Latin and French words are really a big component of the language. And that was so because those words had already established some kind of legally fixed meanings. And this is, think of it, English as a language is developing in parallel. And there is a legal system which is continuing, which is using Latin and French words and continues to use them because they were more established and they were better known. There may not even have been at that point in time an equivalent English word, English word. Okay. So while the English language as common speech developed and evolved on one track, the lawyers remained stuck on one track with the lowest Latin and French words embedded in there. And the fear was that if I use a new word, which has not been used, although it may mean the same thing, but it's not been used in the past, the precedents may not help me. So English equivalent words were not used by lawyers, even though they were there and present and had evolved. So you were worried about the precedent and you did not want to use a new word or a simpler common speech word because you felt you do not know what it may mean in a court of law. Where are the words actually? Many of them, as you know, are still in use. So you have many Latin words. You have French words, meets and bounds, estoppel, quasi. A lot of the words, vi major, pari passu, a lot of these words are French words or old French, not even new, modern French, old French and Latin. And as Justice Lokur said, a lot of people feel that, Latin makes you look very learned. I mean, in fact, I had a young colleague who joined me once, gave me 2 paragraphs written on something, and, it was full of a lot of Latin. And I actually asked him, I said, young man, you speak Latin at home? So he was a little surprised. He says, no, sir, we don't speak Latin at home. So I said, then why do you use so much Latin in this? So he says, you know what, my previous senior told me that it makes you look very scholarly and very learned. So I said, well, in that case, we must see. I like to learn Latin, more. So let's just look at it and see which is the closest place to Delhi where Latin is formally taught. And we found a school in southern Italy, 4,800 miles away, is the closest place to Delhi where Latin is taught. So we use a lot of Latin as part of this. So let's see this. Other is term of the art or languages or jargon. Now, all professions have their special vocabulary. I call them fuzzy-wuzzy words. So whether it is a chemist, a mechanic, plumber, painter, architect, whoever, they all have their fuzzy-wuzzy words. And their fuzzy-wuzzy words of a profession are of 2 types: term of art and jargon. And as Justice Lokur said, we are the privileged class as lawyers where our junk, our jargon, our professional fuzzy-wuzzy words actually have a name, and that is legalese. And obviously it's used generally in a pejorative sense, in terms of people making actually fun of our language of the law, which we lawyers and we judges are very proud of. So what is term of the art? It means something which is very precise. It has a precise meaning given in any specialty. In our law profession, any word which we claim as term of art gets that standing through persistent professional use in only one way to achieve a specific legal end. So I'll give you some words here, which are, of course, term of the art, and many of them are also understood by common persons, people on the street. So for IP lawyers, for example, or people in the business, infringement, passing off, prior art, assignment, license, injunction, damages, many people understand these words. Mortgage, alibi, agency, surety, bail, laches, lessor, lessee, plaintiff, defendant, suit, contract, all of these are actually term of art. They all carry one defined specific meaning. The trouble is, and this is where the rub lies, that most of the rest of what we use as legalese is jargon. It's also described by some as argot or a slang that is, used by a common group, as a secret language used by a common group, literally. Most of it fails the test of term of art. And statistics show that in normal legal writing, it's about 3 to 4% of the words which are truly term of the art. Rest of the words that we pretend are term of the art or very precise are actually junk and jargon. Here are some other examples. At issue, cause of action, court below, due care, four corners of the instrument, purported, set down for hearing, times of the essence, hereof, thereof, whereof, same such, said, aforesaid. Those are the words that Justice Lokur referred to as well. All of this is jargon, argot, and junk. All of this has no place in any modern contemporary language. Too many words. Repetition, doubling of words, superfluous words, and which really add no real meaning. Now look at this. All of us are familiar with this. Now, therefore, in consideration of the premises, the representations, warranties, covenants, and undertakings of the parties herein after set out, and for good and other valuable consideration, the parties agree among themselves as follows. This can be replaced with just this. The parties agree as follows. Everything else that you see on top is absolute rubbish. It has no meaning in law, zero meaning in law. But we persist. We use those too many words. And then I want to talk about word doubling, which is duplicating words with identical meanings from different origins. So as I mentioned earlier, many languages have contributed. So what happened that as precedents came along and a word in Latin was given a meaning and then a word in French was given a legal meaning or accepted and precedents got created, lawyers started doubling up to be absolutely sure. So have a look, for example, null and void. This is Latin is null, Old French is void. And now we modern lawyers have added more to it. So we now say null, void, and of no effect whatsoever. So where a word null or void would do, now we use 10 words where one would do. Will and testament, they mean exactly the same thing. It's Old English and Latin. So every second will that you will see in this country on top will say will, and then it will say this is my last will and testament. Fit and proper, this Old English, French mean exactly the same thing. Save and accept, it is French and Latin, mean exactly the same thing. Both words mean exactly the same thing. And then we also use extra word to add emphasis. How many of us have written a sale deed which says, I hereby transfer, assign, sell, convey, all meaning exactly the same thing. Have and hold, from and after, let and hindrance, each and every. We use these words every day without thinking twice. We continue to use, so we have too many words. So since Shashi was mentioned, and as Dr. Qureshi said, and just as we all are from the same alma mater, and Shashi is one of our stars. So I have actually a slide dedicated to him. And that slide is coming up next on big words. Don't use a big word when a singularly unloquacious and diminutive linguistic expression will satisfactorily accomplish the contemporary necessity, which just simply means use small words. Okay, but I will share on the screen the famous judgment of our Chief Justice, and you shall see how he was trying to impress everybody in the world. So let's just come to now construction style. So the long sentence, I call it the curse of the long sentence. And this is an article, or actually a book. An entire series of Justice of Lord Denning are amazing, but one of his best is called The Closing Chapter. And in that, he has an essay on plain English. And this is what Lord Denning says. If you use an overlong sentence in your speech, you will lose your hearer before you get to the end of it. He will not be concentrating as much as you are. If you write an overlong sentence in your opinion or judgment, the reader will get bemused. He will say to himself, I must read that sentence again so as to get the hang of it. That destroys its effect altogether. So, and the beauty is that fixing the long sentence is one of the easiest things that we can do as lawyers. So the core problem that we have is that we will shove in too many thoughts, too many different ideas in one sentence. So within the sentence, we'll have the main theme, we'll have the details, we'll have qualifications, exceptions, conclusions, exceptions to exceptions and consequences. Okay. And it's a very simple tip that I follow. One thought per sentence. And I'll give you an example so that you understand what I'm saying and also understand it from the perspective of a reader who is not familiar with reading legal documents or long documents. So look at this. This is from an actual contract. Nagarjuna Coal Company Limited is a company engaged in the mining and selling of coal, its mines and place of business being located near Nagpur, Maharashtra, whereas Narmada Coal Company, Mining Company is a company engaged in buying and selling coal located in Ahmedabad, Gujarat. It's one sentence, 44 words, not a very large sentence. But see what happens to a reader. And when you look at that sentence, you say, so it actually has 4 thoughts in it, which have not much bearing on each other. Only when you get to the middle somewhere, you may start understanding that Nagarjuna Coal Company is not selling its mine and place of business. And it remains doubtful who's located in Ahmedabad, the Narmada Coal and Mining Company or its coal. And the problem is, and that's what research has shown over the last over 100 years, the flow of words is such that the mind gets transported from the beginning of the sentence to the end with confusing suddenness about the businesses and locations all muddled up. So this is what I have done. I just put 4 full stops. And Americans say period. They have a good reason to say period, which means it is when you stop, you pause. So Nagarjuna Coal Company Limited is a company engaged in mining and selling coal, full stop. Its mines and place of business are located near Nagpur, Maharashtra, full stop. Narmada Coal and Mining Company is a company located in Ahmedabad, Gujarat. It is engaged in buying and selling coal. So I tell always my young associates and anyone who comes up to me with a long sentence, and I say, friend, Full stops are free. Nobody charges you anything for using full stops. Please use them. Please use full stops. This is the famous one, dear friends. This is 299 words. First sentence is 73 words. Second sentence is 226 words. Big, pompous words. Large, big sentences. And this is the one which elicited that article called Justice by Thesaurus, because most of it actually is fairly rubbish. I simplified it. This is what Chief Justice Deepak Mishra was actually trying to say. Is criminalization or defamation constitutional? Question mark. How to balance these two rights, the citizen's fundamental right to freedom of speech and the rights of others to effectively protect their reputation. 2 sentences, 29 words. Let's go back for a minute. This patch of it, which I don't want to read it because it gives you a headache. But that's what he's trying to say. This is what he's trying to say in that. Okay, let's go to voice. As we know from our school grammar, voice is the relationship between the subject and the verb. So active voice, subject performs the action of the verb, then the sentence is active. And passive voice is subject is recipient of the action, then the sentence is passive. And my favorite illustration is this. Passive voice, the mouse was eaten by the cat. Active voice, the cat ate the mouse. Now, one of the big problems of language of the law is, and construction style is, our use of passive, too much use of passive voice. And that complicates lives for the readers. So why? Because it's abstract. And I say you why? It's abstract because the normal human comprehension pattern as shown by research is that there is an actor who performs the action of the verb and something happens. This is how our natural wiring of the human mind is. And passive voice basically belies that. Then we also have other ways in which passive voice gets confusing. For example, the actor, that is the person who's doing something, need not be mentioned. Passive voice sentence is also longer than the active voice sentence. See this one here. It leads to vagueness. A mistake was made. Grammatically perfect sentence. But what does it do? It actually literally hides the blameworthy. It hides the actor. Okay. Let's take a couple of examples. The union filed a complaint is active. A complaint was filed by the union. It's longer by 3 words. The trial judge will deny your application. Your application will be denied. The legislative history supports our conclusion. Our conclusion is supported by the legislative history. And if you see the second example, the actor is missing. The trial judge will deny your application translates to your application will be denied. The actor is not even mentioned as to who will deny it. Nominalization is another favorite of the lawyers. And that is, we actually convert a verb into a noun. And I'll show you how that happens and what it does. It actually buries the active verb and makes the sentence longer once again. So I'll just give you 2 examples. The firm has made the decision to undertake the representation of IILM. This is with buried verb, and I'll describe to you where the buried verbs are. They are actually in dark blue. And the active verb simply says, the firm has decided to represent IILM. The licensee will furnish an indemnification to the licensor. The licensor will indemnify the licensor. So through nominalization, we weaken the verb and we create a new word. Now you can see the firm has made the decision. Now the decision here, actually from the verb, we have created a noun. The verb is decide. We've created a new thing. So we have made the decision is simply substituted by decided. To undertake the representation of is simply replaced by represent. So I tell my young colleagues I said, be mindful of the ION words. I call them the eon words. Look at the eon words and eliminate them. So you'll see all the eons here coming. Indemnification, representation, decision. So you find the eon words, you will find buried verbs. You replace the eon words with an active, strong verb. Compound phrases, favorites of the lawyer will use a long prepositional phrase, which can typically be substituted by just one word. And interesting thing is, this happens to us more when we are writing, not when we are speaking. Take this example. In the event the plaintiff files documents, if the plaintiff files documents. So in the event is replaced by simply if. Now just think of it in common speech. I mean, do you tell your friend, in the event I come to your house, or in the event I go to Delhi? You'll never say that. You'll always say, if I come to your house or if I go to Delhi. But when we lawyers get the pen in our hand or our hands on the keyboard, something happens to us. And that's when we start using words like this, or expressions or compound phrases like this. With regard to, in close proximity, in light of the fact that, in order to, in the course of, in manner in which, in the instant case, these are the proposition word we use. Now let me give you the simple one word replacement. With regard to, about, in close proximity, near, in the light of the fact that, because, or given that, in order to, just simply to, in the course of, during, in manner in which, how, in the instant case, this case, is binding on, is unable to, can't, is desirous of, wants, on the part of, by, and prior to is before. All these on the right are common speech, day-to-day English language words, which are absolute equivalents of the string of words that you see on the left. Now I come to plain English. It says, you heard that much of this from Justice Roku, but let me go over it again. So the first test of the language is, does this language clearly, concisely, and comprehensively communicate or not? So why don't we apply that test to legal English, or to legalese? Second, are citizens entitled to know what rights and obligations the Constitution confers on them? Is this the domain only of lawyers and judges sitting in the Supreme Court and the High Court? Or is it of every person who's a citizen of this country? Do those impacted by law or regulation have a right to understand the code of conduct expected of them? Every law. Are citizens entitled to understand judgments and opinions given by the judiciary? Do parties to the contract have the right to understand the promises exchanged by them? And is the public at large entitled to be aware of the things that really matter to them, even if they do not grasp the details? This is the question that the profession, or the questions that the profession the drafters, those who draft legislation, those who draft contracts, those who write academic papers, as the judge said, we have to ask these questions to ourselves. So, sorry, this is a duplication here. Now, over the years, many of the greatest writers of even the legal English and jurists and judges and lawyers have pleaded for and promoted the use of plain English, plain language. Thomas Jefferson, the second president of the United States and one of the key drafters of the Constitution. And you heard the judge say a little bit about this earlier today. In drafting statutes, my fellow lawyers have the habit of making every other word a said or aforesaid, and saying everything over 2 or 3 times, so that nobody but we of the craft can untwist the diction and find out what it means. The most valuable of all talent, that of never using 2 words where one will do. And again, coming back to my favorite person, Lord Denning, see this here, what it says, and I wish Justice Deepak Mishra would read this someday. Don't use long words. Unless your hearers or readers understand them, you may understand them yourself, but they may not. If your hearer says to himself, that is a word I've never heard before, what does it mean? You have failed. If your reader says, I must look it up in the dictionary, again, you have failed. You have not conveyed your meaning to him. A lot of speakers and writers do not appreciate the simple truth. They use long words so as to show off. Think about this. One of the greatest jurists of our time. There are people who've done PhDs, by the way, on Lord Denning's writing style. He was the first one who introduced titling and subtitling and paragraphing and subparagraphing judgments in England. And I'll show you a piece of his work shortly. This is David Malenkoff, probably the best historian of the language of the law. Most law can be expressed in ordinary English, most of it is. But by the time lawyers get through mushing up ordinary English, very few English speakers and only some lawyers can recognize it. They throw in words that were headaches before the age of steam. They try to get by stuffing law into sentences that aren't built to take that load. Instead of rejecting the rubbish and keeping the good in the language of the law, they swallow it whole and end up with law sick. I love this word, law sick. That's what we do to people. So why do we persist? Why is it that when our readers and those who we service, they do not understand much of what we say? So why does this happen? So let's have a look at some of the reasons as to why this happens, some of the possible reasons. Okay. So as said earlier, at one point in time, law was indeed the domain of the elites. Those are the people who studied French, who studied Latin. It didn't have anything to do with most people because most people didn't have any rights. It only concerned the court, the royal court, the courtiers, and the aristocracy. But now, everyone, all lay people, they all have rights and obligations. They have rights and duties. So forms and conventions, what I earlier read to you, but now therefore in consideration whereof, those are the things which have zero relevance in this day and age. Because we lack the knowledge of the history of the legal language and how it has evolved, we have therefore a huge fixation on precedent, which is misplaced because I will talk about that as well. And this is the most important part, and there's several students here. I have been a victim of this. Legalese got handed down to me from my seniors, that this is how it is. And if you asked a question, you were just simply put down with the idea, do you want to be a lawyer or not? If you want to be a lawyer, this is how you have to write. That's what we were all told. That's how we were taught. And the beauty is here, and we are talking to students and to faculty. No one teaches us how to use words. Words are the tools. And I say it is like a plumber not knowing how to use a wrench. 80% of our time, maybe more, is spent in reading, writing, and articulation. But nobody tells us how to use that toolkit, how to use the tools. So we are told and taught convincing how to write a lease deed. So people mug it up, and the day of the exam, they come and they vomit it on the paper, and everyone says, well, wow, great. So I've learned how to draft clauses. And as I said in the beginning, I think what we have to first learn is how to use the tools, how to use the words, how to put them together, how to construct a good sentence. I don't have to teach you how to write a clause. I have to give you the tools. I have to tell you how to use those tools, and you will build your own beautiful sentence, and you will build your own beautiful paragraphs and a whole document. So writing skills, frankly, of that type are absent in law schools, in law school curriculum. And I put this challenge, and I put a challenge now. People can go to chat and give me an answer to this, that how many of the faculty and the students have actually read a book on legal writing? How many of them can name an author, an authoritative author on the subject? And in large rooms full of very senior lawyers, the answer has been a blank largely, as far as I'm concerned. And it was a blank for me 10 years back. So why do we persist? Good answers. There is a very strong perception in our audience which says we deliberately do it. And Jeremy Bentham was the first one 250 years ago. He says we deliberately use a complex language. Lawrence Friedman is one of those apologists. Legal style and vocabulary of lawyers are indispensable for the cohesiveness and prestige of the profession. And see the other side of that coin. Stuart Aubach, who was a very well-renowned legal reporter for the New York Times, he said, the lawyer's language serves as a secret handshake in a fraternity, letting others know you are one of the tribe. So we do it to exclude. We use a certain slang, and we are proud of that because we want to exclude others from that community. And sorry, this is coming again. There is some challenge. All right. The most important one that I keep on hearing, and it's the most false one, is legalese is precise. It's a false pretense. And let me show you how. So first of all, the real tiny bit that is precise is term of art, nothing more. Most of it is pretentious, it's vague, ambiguous. Otherwise, how do you explain 70 volumes of words and phrases legally defined? 70. And look at this stat. This was part of my essay I wrote a month back on how shall is such an overused and misused word. So shall, which most of people here would on the first instance say, usme kya hai? We all know what shall means. You'll be surprised. There are 1,300 judgments from around the world common law countries, over 100 pages in words and phrases legally defined on shall. Judges have held shall to mean may, might, should. They have held it to mean many different things, believe it or not. So there's not much precision in our language. We pretend that there is. So the top one, I think, is the most important one. And I've had some personal interesting experiences with this. A few years back, when I was a very new, enthusiastic promoter of plain English, a colleague of mine brought me a contract which had come from another law firm. There were, in one part of it, there were 2 pages of unbroken text. So I told him, I said, you know what, let's break this into paragraphs. Let's give heading and subheadings, and let's put some sense into this. This is ridiculous. So we did that. We sent it back. 2 days later, the contract came back with everything restored the way it was, and with a little comment in a footnote which said, Lawyers don't write like this. It is absolutely true that if you try and introduce anything new, anything which is contemporary, which is not so conventional, this is what you will hear from your profession. But I think there are other reasons. I think it's very economical for us to use old forms. I think we are lazy. And the other thing is, I think we simply don't care about our audience, as the justice said. We don't care about our audiences, and there is no disincentive. There is zero disincentive to change. And I firmly believe, and so do many others, I'm ashamed to say that as a lawyer, that it is strategic in some industries like insurance and banking and consumer-facing industries where you hear the proverbial small print. They actually want to make things difficult because if the consumer understood what she's signing, she will never sign it, or she will question it, or she will raise doubts. Is deliberately done in many, many industries. And of course, it's a subject of jokes. Translate this easy to read statement into legalese, Wilson, so the consumer will have to hire a lawyer to explain it. I'm telling you, I have seen boarding pass, I won't name the airline, it still exists. The boarding pass still exists, which is full of legalese. A boarding pass. I mean, forget about a warranty for a refrigerator, which a housewife needs to understand, or your insurance policy. You need to understand what is covered, what is not covered. A car warranty, what you're entitled to as a first service, is unbelievable. Unbelievable of what we inflict in what we call adhesion contracts, B2C contracts, which is business to consumer contracts, are so terrible. So, plain English movement, many, many countries around the world have been on it for the last about 30, 40 years now. Particularly the consumer right movements in many of the common law jurisdictions actually have led this in terms of saying that whether it's the proverbial small print or all of those items. I mean, I have seen laws in Pennsylvania, state laws in the US in many states, where they actually have guidelines, which actually refers to Fleisch's reading formulas, which actually says your sentence should be more than so many words, and you have to use active voice, believe it or not. So there are states which are actually laying down that for consumer-facing documents, you have to make them simple and plain, even if you don't do them for very difficult, tough legal documents. England, Canada, Australia, New Zealand, all of them have certainly communication of the government concerning citizens and the public. America has the Plain Writing Act, which was brought in by Obama in 2010. And of course, the legislation in all of these countries have legislative drafting manuals. England, Australia, New Zealand, Canada, they all have, which, for instance, Australia now, shall is banned. They do not use shall. If it's a mandatory obligation, it is used as must. They have the federal appellate court rules in the US have been redrafted a few years back. There's not a single shall in the whole rule. The entire rules are shall-less. So people are doing this at the moment. And many, many, many in the legal profession are leading the reform. The London law firms in the early 90s started the process of simplifying a lot of this. And it happened when the top 5 London firms called the Magic Circle, they started adopting this. And then the most of the industry started to follow suit. So let's see what's happening in India. We all know that we picked this up. We got it as an inheritance. We never really learned it. We adopted and continued to pick and use. There is still huge amount of lack of awareness and absence of skill training in law school and in the profession. As Justice Lokur earlier said, a lot of our legislation, primary and secondary, continues to be complex. I encourage people to read the latest code of which has come in the labor code. There are sections in it, and particularly anyone who's interested, I can refer to at least 2 of them. That is section 85 and section 87. Incredible. They are difficult. I have been practicing law for 46 years now. One of them I still haven't fully understood as to what it means. So either I'm absolutely foolish or the other thing is very difficult. I don't know which is true. VD's manual on plain English legislative drafting was done, but sits in some dusty place somewhere because the Department of Legislature in the Ministry of Law refuses to change. They continue with their old style. The Curriculum Development Committee, some of you would know, I think, if I'm not mistaken, I think Dr. Ranbir Singh was part of that, which was set up by Gopal Subramaniam in 2009, when he served as an interim chairperson of the Bar Council of India. And they brought out a very brilliant proposed syllabus for the first 2 years, and it was put up on the website of the Bar Council of India in 2010. And in that, they had a whole subject on legal English. And that committee, that you can, by the way, anyone interested can still go to the website of Bar Council of India, and after 11 years is still sitting there for public comment. Our Society of Indian Law Firms, we have over the last 2 years taken initiative to promote use of plain English. There is a start of the campaign. Over the last year, we have been running training programs for lawyers from law firms to understand some of these things and to start implementing them. Now, I am literally on the last slide so archaic and stuffy prose is out. We have to gently, please. We need to feel comfortable with contemporary style. So why instant case and why not this case? And why inter alia and why not among others? It's simple. And we can make a modest beginning. All the reds are the ones that we can avoid. Latin and jargon, ancient words like hereof, thereof, difficult and superfluous words, long sentences and passive voice. We can adopt and start using simpler, commonly used words, lesser number of words, make subject, verb, and object together, hang together in the beginning of the sentence as much as possible, use shorter sentences, use active voice. And I bring you back to Lord Denning. A massive unbroken page of print is ugly to the eye and repulsive to the mind. A long unbroken paragraph is indigestible. Split it up into sentences. If you find that you must have a long sentence, break it up with a suitable punctuation. And look at the master. 3 words in the next sentence, sometimes a dash, full stop. At other times, a colon or a semicolon, full stop. Again, a 3-word sentence, often a comma. It enables the reader to get the sense more readily. And look at the master at work. I urge you to please read this paragraph. It will take you 2 minutes, and I think I'm still within time. Very well within time. And I want to say something about this. Now, look at the judge. In one paragraph, he sets up the legal problem. What is at issue? Compare it to our Chief Justice's opening paragraph. He sets out the facts. I can tell you that an 8th grader who knows English, if he reads this paragraph or she reads this paragraph, will be able to understand what is at hand. What is it that the judge is trying to decide? And this is his judgment, opening paragraph, British Railway Board, Customs and Excise in 1977. 12 sentences, 248 words, Sentence length, longest is 38 words, shortest is 7 words, average sentence length is 20.7 words. This is what is called legal writing. That you can explain the most complex proposition in simple terms. This was the judgment of 2018 which Justice Lokur was referring to. He didn't take the name of the judge. I don't have any hesitation. The name of the judge is Justice Sarveshwar Thakur of Himachal High Court. This is part of the judgment. It's available on the net and it's worth reading. This is the judgment which was before, I think it was before Justice Lokur and Justice Shah, if I'm not mistaken, but I know that Justice Madhan Lokur was there in that bench. And this is what happened. On appeal, a bench of the Honorable Supreme Court of India, having failed to understand the judgment, set the verdict aside and sent the case back to the High Court judge for redrafting his judgment. According to a newspaper report, the bench commented, we'll have to set this aside because one cannot understand this. Now, I'm going to end with a clip, and I hope you'll be able to hear it or what it is. And Qureshi, मेरे बड़े भाई, अगर आपको सुनाई देगा तो आप थोड़ा thumbs up कर दीजिएगा, so I know that you are able to hear it. Okay, so this is one of the most hilarious clips of one of my, it actually is much loved TV serial, as I've said here, of the 20th century. So let's see if we can. सुनाई देगा तो बताइएगा.
At the lot, Bernard? Well, before you go home for the holidays, Minister, Sir Humphrey has something to say to you.
Thank you, Bernard. Minister, just one thing. I wonder if I might crave your momentary indulgence in order to discharge a by no means disagreeable obligation which has over the years become more or less established practice within government circles as we approach the terminal period of the year, of course, not financial. In fact, not to put too fine a point on it, week 51. And submit to you with all appropriate deference for your consideration at a convenient juncture, a sincere and sanguine expectation, indeed confidence. Indeed, one might go so far as to say hope that the aforementioned period may be, at the end of the day, when all relevant factors have been taken into consideration, susceptible of being deemed to be such as to merit a final verdict of having been by no means unsatisfactory in its overall outcome, and, in the final analysis, to give grounds for being judged on mature reflection to have been conducive to generating a degree of gratification which will be seen in retrospect to have been significantly higher than the general average.
What's he talking about? Well, Minister, I think Sir Humphrey just wanted to crave your momentary indulgence in order to discharge a by no means disagreeable.
All right, Bernard. Humphrey. At the end of the day, Minister, all these things being... Yes, Minister.
Are you saying Happy Christmas?
Yes, Minister.
Okay. So I'm done with that. That's what we do, right? Just imagine.
So thank you, Mr. Sagar, for this very lucid and detailed presentation on the effectiveness of legal writing. And I felt like I'm a professor of management. I felt like sitting in the class of history of English language and also history of legal language, the way it has evolved in India. So it's a great, and I'm sure that we are going to use these videos in our classes, in our law school, and it will be great learning for students and faculty members. I've already got demands for PPT from the participants, so I don't know whether we will be violating intellectual property right of Mr. Sagar. Okay, so
free to be used. I mean, I'm quite happy to share it. So I will. I probably need to use a Dropbox or something. I'll send it to Sanjay. So you are free to use it. This should spread it out as wide. This part of the campaign.
Yes. So thank you. So sir, I got to know about the closing chapter, the book called Closing Chapter by Lord Denning. But as a lay person, I understand that developing a reading habit influences our writing. And are there any books available in the legal profession which can, promote, which if I read, I start writing in a plain and simple English? Because if I have read, suppose my favorite is Mahatma Gandhi's autobiography, My Experiment with Truth, or Ernest Hemingway, The Old Man and the Sea, where I have learned how to write simply and clearly. So do you have your own favorites, both in the general and also in the legal profession?
So there are a couple of thoughts there, which I would say, first of all, frankly, Denning is the best.
Yes.
And I think Justice Lokur is there, and he will probably endorse it, that his judgments and his style of writing, the simplicity, and how beautifully he writes. I mean, I think, as I mentioned earlier, there actually are PhD theses in literature on Denning's literature. I mean, It is incredible. Now, Denning has written a number of books. In fact, quite interestingly, the closing chapter was, in a strange way, his first book. And that was a time when he was just stepping down. He died at the ripe old age of 100 in 1999. He was born in 1899. So the closing chapter is a selection of essays. And apart from that, there is a series of books which are all published by Universal Book Company here in India. They are very reasonably priced.
Yes.
All of them are 450 to 500 rupees. And it's an anthology. It's about 6 books written by Lord Denning. They are all available. I would say that to every student of law, I would say to every judge, read Denning. And really it improves. It's huge in terms of language. Now, in terms of writers of the English language, of course, there are the language of the law. I think the most prominent of them is Brian Garner, completely outstanding. You can simply Google Brian Garner and you will see the work. And he also has been the editor of Blackstone's Legal Dictionary for the last many, many years. But his work over the last, and he has authored 2 books with Justice Anton Scalia. They were very good friends. I have all of the books of Brian Garner. Joe Kimball is another great writer. Ken Williams on drafting of contracts. So there are several. Then there's Hans Dramstadter, who actually wrote a book from where I stole the title, Hereof, Whereof, and Everywhere Of. So there are very many contemporary writers. But I would say, look at Denning, read Denning's books, read Denning's judgments. If you really want to be a good writer as a legal professional, go with Denning. I mean, I have found that to be, so in my reading list, that'll be number 1. In my reading list, then Elements of Style by Brian Garner would be very high. So there are many books by Brian Garner. I can go on. I have there are about 12 or 15 volumes that he's written. And people interested in history of the language of the law, the most comprehensive work is of David Malenkov, published in 1963, by the way. And again, beautifully written book. And then those who want to read just the smaller one, the good old White and Strunk is there. Richard Wydack's 75-80 page book on plain English is there. David Malenkov also has a thinner volume called Legal Writing, Sense and Nonsense. So there are plenty of books out there. The unfortunate part is that it's not so much promoted or read or even part of the curriculum in any of the law schools that I know of. So in India,
we'll certainly like to incorporate in our law school and buy those copies also. If I can ask Justice Lokur his favorites on the legal writing, the books which influenced him on that.
Yes, Lord Denning, of course, is number 1. But I would also place Justice Oliver Wendell Holmes as number 1, a joint number 1 with Lord Denning. Justice Holmes passed away in the 1930s, so he's like many years ago, but outstanding. So I think if, for judgments and all that, and for good legal writing, I think these two are top class. Of
Yes.
course, if you're looking at general literature, other than legal writing, you have some outstanding authors, Charles Dickens, for example. So yeah, there's plenty of it going around. And like you said,
Yes.
if you read something, it definitely influences your style of writing.
Yes.
That I would certainly go along with that.
Yes.
And
Thank you.
actually, I may add, by the way, which I may add, Alice in Wonderland.
Yeah.
Yeah.
It's an incredible book for language.
Yes. So thank you. So one more question here. So dealing with complex issues like energy, power, healthcare, life sciences, technology, capital markets, securities, and you will get to use a lot of jargons because that's how the subjects are well defined. So how will you not bring those legalese or the jargons from those subjects in the judgment or in drafting? So what's the way out in that? So that common people can understand the drafting also as well as the judgment.
Yeah, Jyoti, go ahead.
Yeah.
Well, I think there are two pieces here which I see. So one is again, and I think can I call you Madan?
Yeah, sure.
I've always called him that. so he referred to in his presentation when he talked about judgments and legislation and so on. So it is true that there is a fair bit of thing which we lawyers and we sort of persons in the legal trade that we write with the assumption that mostly it will be read largely by lawyers or a common person who is, either who gets to understand it from a lawyer. But what's happening today, and that's where the differences come from 1280 from Magna Carta to now, is the layperson's rights and obligations and duties, and how law touches every aspect of our life now. I mean, if you look at the number of laws that existed in 1250 in any country, people say we are over legislated in India, but I'm talking more generically. Look at the number of laws which govern everything from what should go into refrigerant coolant to consumer safety to all sorts of things. So what has happened is that on the other side, and that's the other side of the coin, and I almost call it, when you talk of business B2C as business to consumer, and I call it as lawyer to consumer, and I call it L2C, I think that translation part is something that we have to deal with. Because there are many terms of the art which are understood. A common person on the street, even when you ask him, and most people who kind of need to have access to these things will know who's a plaintiff, who's a defendant. I don't tell him, ki jis aadmi ne suit file kiya. I don't have to say that to him. If I say plaintiff, he will understand. Lease, lessor and lessee, landlord and tenant. Most people will understand. Most people understand some simple terms, even of mortgage and things like that. So there are many terms of art which are fully understood. There could be some concepts, like a lot of the Latin stuff that people will use, as Madan said earlier. Actually, there is no need. There is no need for that Latin stuff. It can be written in simple and plain English. So this translation of L to C, I call it, is where the challenge lies. And we have to start at probably the lower end. And that's a low-hanging fruit, as I call it. Is simple things like consumer-facing documents, right? Application forms, right? Warranty cards, insurance policies, your car registration. And I'm giving you, instance after instance, and I gave you the instance of a boarding pass of Vistara airline. I can name it now. Have a look at it. The boarding pass is full of legalese. So there are consumer-facing things on which the communication is to the consumer, and I think we need to start fixing the problem there. There will be, if two doctors are having a huge discussion, let me put to you, about a patient who has cancer. They are discussing it. Now, when they have to discuss that with the patient, what would they do? You had that experience where the doctor is trying to explain to you a very difficult a technical issue. They have learned that art of doing it. When they talk amongst themselves, they'll talk in highly technical language. But when they talk to you, they will dumb it down. They'll make it simplified to say that you needn't to know all the details, but you know sufficiently about the issues involved, about what is at stake here, and what it may mean to you. So I've given a very long, convoluted answer, but this is work in progress. So there will be some areas of law where you will end up using technical terms. But as I said, research shows not more than 4% of the words technically are really term of the art. Rest that what we claim to be term of art is actually jargon and junk, which can easily be replaced by simple words and by conventions. Like I told you the story of the party, the first part, there's no need to say that. Why don't you give the names to the parties? Use their first names if you have to. There's simple things that we can do to make life easier for non-lawyers. And I think that should be the first goal of any plain English movement. How do we make life simpler?
Jyoti, may
for
I ask?
non-lawyers?
Yes, sir.
You know, the term of art itself is a jargon which you introduced and I heard for the first time. Is it, can you replace it with something simpler?
No, term of the art means a word. An art is, it can be plumbing, it can be electrical, it can be atomic, it can be whichever art. So term of art is of that art. The plumbers use their, mechanics use their own. When they start talking complex thing about carburetors, you will not know. So those are some terms, as I said, where the legal meaning is fixed. But for example, I give example of shall. I think Madan knows that I wrote that article about, month, 6 weeks back, that how shall is used in, actually been interpreted in 8 different ways. Now for shall, for a lot of the people said, oh, bada mazboot word hai. That is what I used to hear. It is the king, shall. It isn't the king. We made it to look like the king, but we use it all wrong. There are many such words that we will use, which are hereof, thereof, same, such. They have zero legal meaning. They have no fixed meaning in law. Now, if I were to use the word mortgage and the case came up before Justice Lokur, he'll immediately know what I'm talking about. That is term of art. It is consistently applied with a fixed meaning, with a fixed legal consequence. I don't have to explain in my thing to say what is mortgage. कि मैंने अपना house bank को mortgage कर दिया. Everybody understands. Even a common lay person will understand what that means. Now, if I have to describe that I've given my title deeds, I've deposited them with the bank, they will keep it. Against that, I have now borrowed money. When I return the money, the title deed will come back to me. I have to describe the whole transaction. Now, that entire transaction is being given one name of mortgage. So we know what mortgage means. We know what license means or infringement means in intellectual property sphere. So there are many words which are very well known and recognized. So that the term of art is actually, if you go to the dictionary itself, it will show you. So each art has its own term. So art means a profession. So plumbing, electricians, atomic scientists, space scientists, doctors, orthopedics, physiotherapists, they all have their lingo. And that lingo has technical words in it.
I just like to add.
Do you think we can? One second. Do you think we can replace the expression art with profession? The term of
not
the
all of
profession.
them. All of them may not be professions as well.
Okay.
Yeah. So engineering, so it's that's how it has been. So really, for us, those special words, which have a special meaning in law and are consistently applied, that is what we will call term of art. And the research shows that in normal legal writing, not more than 4% really are term of art. So Professor Mishra, is the problem with those 4% out of 96? Today, it is the other way around. You saw Justice Mishra's opening paragraph.
Yeah.
There are words in it which are not legal, which are not, they are just words. That's one of the big problems.
Yes. Yes. I think
I just wanted to add 2 points. one about what Jyoti said, that, party of the first part and all that. Now, in judgments, we tend to use respondent number 3, the respondent number 5. Now, who is respondent number 3? I have to go right back to the beginning of the judgment to try and find out who is respondent number 3. Now, respondent number 3 has a name. Why can't I use it? So, or a plaintiff, there could be 4 or 5 plaintiffs. And I say plaintiff number 2.
Yes.
What does that mean? Okay, so I think there is, judgment writing, of course, has to undergo a massive change. The second thing that I just wanted to mention was about this use of technical words. You see, now what has happened is that we have all kinds of tribunals, telecom tribunal, this tribunal, that tribunal, and we have specialists in those tribunals. So they have grown up using these words. So they think, like lawyers, that everybody must be understanding it. When I use a particular word, if I understand it, why can't you understand it?
Madan, just think of what happened with average gross revenue. Just see what has happened with it in the telecom industry. It's going to kill the industry.
Absolutely. It has. I think it has almost killed it. But anyway, so here you are.
Close to it.
So this is an excellent example. So everybody thinks, I know, since I know it, everybody knows it, but that's not correct. That's where, legal writing has to undergo a change, judgment writing has to undergo a change.
So thank you, Mr. Jyoti Sagar, Justice Lokur. Thank you so much. It's such an enriching session for all of us. I think I have run out of time because there are a lot of questions which are there in the chat box, but now I invite Dr. Kakoli and Dr. Lori for the next session with Professor Dr. Ranveer Singh.
Thank you, sir. A very good afternoon to our esteemed panelists, teachers, students, and all the attendees. With great privilege and honor on behalf of the ILM Law School, I would like to introduce our next eminent speaker, Professor Dr. Ranveer Singh. Professor Singh needs no introduction. He's a renowned institution builder and a distinguished legal academician of our country. He's the founder Vice Chancellor of NLU Delhi and Nalsa University of Law. With over 2 decades of experience in heading the law schools, he's a visionary who has contributed towards changing the legal education landscape of India. He's a member of prominent national and international organizations like Board of Management, International Association of Universities, Paris, Eminent Persons Advisory Group, Competition Commission of India, to name a few. His legal writings span the areas of jurisprudence, human rights, legal education, legal aid, personal laws, and justice education. It is our honor, sir, to have you for this faculty development program. A very warm welcome to you, sir. With him, we also have from our side, Dr. Kakoli Singh, Pro Vice Chancellor, ILM University.
Thank you. Thank you very much. My 2 promises to you, I'm going to be very, very brief and very, very simple. We had very scholarly lectures by Honorable Justice Lokur and Mr. Jyoti Sagar and others, and Dr. Qureshi briefly inaugurated the program. I would be mainly concentrating on how we do it in the law schools. What kind of a culture we need to create where we nurture legal writing and research. And this I would probably, the best thing would be that I share my own experiences at the law schools for being with the law school in Hyderabad and in Delhi for almost roughly 22 years. Dear Vice Chancellor, Honorable Justice Lokur, Dr. Qureshi, Mr. Jyoti Sagar, faculty members, ladies and gentlemen, students, faculty. Extremely privileged to speak to you on this relevant, important topic for faculty development program. I have the benefit of learned speakers, those who have said a lot of things, and what I shall have to repeat what they have said, many of the things. But I take shelter under what André Gide, the French philosopher, statement said, it is good to repeat things. So please don't mind if I somewhere repeat things. When I'm often invited by the law schools at their orientation for the new students, those who come after 10+2, young batch of students to join a law school, one question I always face, and that question is that the students of the law schools, they get very good placements after 5 years in best of places where they want to go. But that is not the case in case of the other law schools. Why it is so? My simple answer to them is, this is because of the research competencies which the students at the law schools develop. Their research writing and the legal writing and research skills are very, very different from the other law schools. The reason is very simple. We at the law schools, by and large, have developed a system where we nurture legal writing and research from the very first semester of the admissions. In the very first year, the students are supposed to attend. You may wonder that for about 15 days, they have orientation in the library itself, where they're acquainted with all legal literature, primary sources, secondary sources, documents, reports, and everything, the database, the software. They are acquainted with almost everything which will help them in their research in the years to come. And with this, they get familiar with the Supreme Court report, High Court reports, and the other important, also international reports. They are also taught to summarize cases in that time. So they have first-hand information about various law journals in all law subjects, including the database and software available for their legal writing and research in the library, trains them properly for finding material for their legal writing and research. And as you know that most of the law schools maintain very good libraries. I have not seen the libraries of many other law schools, but as far as NLU Delhi is concerned, many years back we surpassed the library of Indian Law Institute. The best of the books, if we have to find out, you find out in NLU Delhi library. Further, this is all done through a structured system of project writing. Let me share with you that every student of law, right from first year, had to do project writing. And that is when they join, within, as I said, within 15 days, once they are familiarized with the library, then in different subjects, the teacher would prepare a list of the projects. Say if there are 50 students, the teacher will prepare a list of 50 subjects, prepare slips, put in a box, and ask each and every student to pick up that slip. And then a list will be prepared that so and so has been allotted so and so project. Those projects have timelines as to when is the rough draft to be submitted, when the final draft is to be submitted, and when the final presentation is to be made. And this research project carries 30 marks. This is done in all the 10 semesters of the 5 years. That means in all the subjects by the student will pass out from the law school, he or she has done 50 research projects. That comprehensively prepares them for legal writing and research. And this is all done under the supervision of a teacher in a classroom in various subjects, because teacher teaching would obviously give the projects, and the same teacher would guide the students that how they do it. And then there is a system in every law school that plagiarism is checked as far as each and every research submitted by a student now will be subjected to that software, which is now available in each and every library. So this is how they do it. And not only this, every student, this project which carries 30 marks, they have to present in the classroom, each and every student. There is a presentation class every day after the projects have been submitted to the teacher. And this is presented to all the 50 or 60 students present in the class. What happens is that after the presentation, the student asks questions from the student. And there are marks for presentation, there are marks for content, their marks for how the particular presenter the reply to the questions, and the footnotes and the style of writing and everything, and the oratory skills, everything will carry marks as far as these 30 marks for the project is concerned. So this is one way of developing legal writing and research with the students. And then there is a very strong system of internship. After the students come to third year or fourth year, fifth year, the students go to internship with senior lawyers, they go to the corporate firms, they go to honorable judges, they go to NGOs where they do their research, and those researches are again presented in the classroom. So that is another part where through internship, they do a lot of research with the various places where they go. I can share two instances with you. I once Justice Hegde said I would like to come to Nalsar, Hyderabad, and he said I will not give any lecture, but I would like to have an open session with your students. And when he started, he said, let me share with you that I was handling a very, very difficult case, and I had a particular opinion that when I decide this case and write the judgment, I'm going to write it this way. But then some people said, probably this will not be the right judgment, which when you discuss those things. And he said that one of your students from Nalsar was interning with me, and I told him to do research and then later on tell me what would be his opinion about this particular problem. And when the student did that research, came to me, the opinion which he expressed was entirely opposite to what I was thinking. But when I went through all those research, read the arguments, I came around and I said I would have been wrong if I would give that judgment. So that is the power of the good legal writing and research. Another instance is Justice Sinha, who was my Chief Justice at Hyderabad, came to Supreme Court here. When I came to meet him one day, he will normally give you a smile, very fine person, but otherwise very strict. So when I met him, he smiled. I said, something special, sir, today? He said, yes. One of your girl students is interning with me. And 3-4 days, I thought whether I was dealing with a very difficult case, whether I should ask that girl to do research for me. I thought she may not find the material. But then one day I called her and said, here is a problem which I'm supposed to deal with. And I wished you should do some research on this. How much time you will take? The girl said, I'll take 7 days or 10 days, sir. I said, no, take 15 days, no problem. I gave that problem to that girl, and I found that after a week, she was sitting in my office. I thought she will say, sorry, sir, I could not find anything for research in this matter. But to my surprise, she gave me 10 pages. I kept those 10 pages with me, read those 10 pages at least 3-4 times, and next day called that girl and said, who has done this research? Who has written these pages? She said, sir, I have done it. Sure, you have done it. She said, yes, sir, I have done it. I can tell you the sources, the way I have done it, the library, the books, the software, database, I have consulted. And Justice Sinha said, I could not believe that the kind of research was done by that girl. And a major part of that research went into my judgment. So that is the power of effective legal writing and research. And that's what I'm saying, that is nurtured at the law school. So the another forum where we do this is the research centers. Justice Lokur would know it that at NLU Delhi, we have about 8 dozen centers. And I can mention to the students and the faculty present here, we have a death penalty center. And in that death penalty centers, when we started doing an empirical research, we involved students because we were to interview those death row victims in the jails all around the country. There were about 400 of them. The students prepared that questionnaire and they went to different states. They interviewed those people languishing in jails, and that was a pathetic situation. Some of the students had to be counseled because they had very difficult experience with them. But that the experience which I want to share with you, that in the death penalty project, we almost had 100 students working on empirical research. And that when the research was finally concluded, they could understand that what is wrong with the criminal justice administration system in the country. Not only the faculty would understand, the student will also understand. And this is another forum that through all those centers, it's not only the death penalty center, the criminal law justice center, the IP center, the banking sector, where we have centers. So the students are very actively involved in these centers where they learn writing and research. Another activity which every law school is doing, including the national schools, that is mooting. Mooting at the national level, mooting at the international level, and initially they go for mooting because they have inter-class competition, they have intra-class competition. And then they learn a lot of legal writing and research. And mooting is one activity where students take a lot of activity of their own. And they feel very fascinated in doing that kind of a research. And they do research in subjects which they are not even studying, because mooting would have sometimes subjects which are not being taught in the law schools. And we feel so amazed that the kind of research they do, the kind of oratory skills they acquire, that is a great experience for a law school. Apart from a very strong culture of mooting, as I said, there are so the mandate of the law school is to produce lawyers, those who are technically sound. We have to probably understand that there is a very fine interface between IT and law. We have seen it recently. We saw the online classes, the disruptive forces because of the COVID suddenly forced us to the online teaching and research. So that is what I mean by technically sound, professionally competent. The activities like mooting, the activities like internship, the activities like being judicial clerks, or going to the empirical research, and then socially relevant. A lawyer, maybe you are a good lawyer, but at the same time, if you are not a good human being, then that's probably there is some deficiency. To conclude, I'm reminded what Michelangelo, the famous artist, was asked, how do you produce statues that are so beautiful? He answered, I do nothing. My job is to chisel a stone and bring out the beautiful statues. I believe in all our students. We have wonderful lawyers, those who are very skilled and very competent, and our job is to chisel them and bring it out. That's how the experience of the law schools probably can shared by other law colleges and the institutions, that how research can be nurtured at the law school. And I promised I will be brief, and I will also confine to what we do in the law schools. Thank you very much for inviting me. Probably you should more often visit the law schools so that you can see how research and writing is promoted by the law schools. Thank you very much.
Thank you so much, Professor Dr. Ranbir Singh. That was a very insightful talk on how research is being given importance. And I have a couple of questions, if I have the permission to ask you.
Sure.
So, sir, you have been instrumental in redesigning the legal education framework in India. So how much importance has writing in particular been given? You've talked about research and you've talked about the premier institutions, but in general, in terms of all the law schools, how much importance has writing been given to the curriculum? And a related question is that because as Mr. Jyoti Sagar gave a fascinating presentation on how long the verdicts are and the judgments are. So when the students and the teachers have these long verdicts as examples, how do they carry on with simplistic writing? So that is my question.
In every law school, we have a legal language, law and literature curriculum, which is taught by, and there is a dedicated teacher to teach this subject. And the students, the question which you are asking from me, the English teacher also, fortunately for us, is a law graduate, and all these issues are addressed. And we at NLU Delhi especially are very keen to promote the plain English movement in the law schools, and that's how it is done.
So the second, thank you so much. The second part of the question was that the examples that they have in terms of long, winding sentences, in terms of the judgments that they read. So how do we bridge that? Having that as an example and writing, short, simple, crisp manner. How does that get bridged?
In the projects, sometime we keep them case laws, and we ask them to probably write it in a concise form and give a critical comment. So that trains them that how to produce or how to write a summary of the judgments. Some judgment at Justice Honorable Justice Locker was saying there are 400 pages, 500 pages judgments, or maybe even longer. So they have to in different subjects. So that trains them in that kind of.
Thank you so much. Sir, I have one more question, please.
Yeah, please.
So you talked about, taking out the lawyers must learn how to be just and how to be sensitive. So what are the measures that we need to take at the law school to come out with the sensitive and, just kind of lawyers?
So I mentioned to you about the compulsory internship, which we have a system. In the first year in the law school at NLU Delhi, we had library internship. In second year, they had to intern with the NGOs. So when they intern with the NGOs, they deal with the various social problems in the country, maybe related to women or children or in other forms. And then they prepare their projects. There have been occasions where some students had their presentation on street children or the children begging kind of thing. And when they presented those research, some of them broke down in the class. And they said, we never knew that these are the problems faced by the country. That's where I meant socially relevant. So law is a very close interface with society and societal problems. And if you familiarize the students at that level, that is very, very useful, probably. So legal aid is legal aid is one activity which is there in each and every law school. The DLSA and the NLSA mandates actually. That mandate obviously is not taken very seriously. That mandates that the law schools should be very seriously involved in those activities which are carried by DLSA and NALSA, National Legal Service Authority, and the State Legal Service Authority. So legal aid is one activity through which we can produce socially sensitive lawyers.
Right, sir. Yeah. Thank you so much, sir. Thank you so much for your inputs. We will definitely try and incorporate as much as we can into our system, into our law school, and we'll bring up with all your inputs and the kind of guidance that we receive. I'm sure we'll be able to reach your expectations.
Thank you.
Thank you. Thank you.
So once again, thank you all our esteemed panelists for sharing your insights on legal writing. Starting from 3 keywords, Dr. Qureshi has said, to classification of legal writing by Honorable Justice Lokur. Jyoti Sagar ji has explained how to simplify the language and the legal writing from passive to active, and n number of suggestions. I think these are the most important takeaways from the session. Then we move to the importance of research, because finally we have to inculcate research mindset or research in our curriculum and research mindset to our students, so they can produce a good outcome from legal side and from our law schools. So thank you everyone for taking out time and coming to ILM for sharing your insights. This one is a wonderful session, and I hope not only faculty members, our students, they all have a very good, important takeaways from the session. Once again,
Thank you.